the screen. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the judge presiding here today. You have been asked to come here for jury service in County Court at Law Number 2. You will be examined or exclusion or inclusion on a jury hearing a criminal case. Our courtroom hours vary. They are normally from 9 a.m. to 5 p.m. Whether you are selected as a juror today or not, you are performing a significant service which only free people can perform. If you're selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected, on the jury, unless instructed otherwise, you will be permitted to separate at recess, for meals, and at night. I have an administrative matter that I must attend to, and that is, I will give you the first of 2 oaths. I would need everyone to raise your right hand. And then after I give you the oath, I need each and every one of you to say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under directions of the court touching on your service, qualifications as jurors, so help you God? Okay, you may put your hands down. Ladies and gentlemen of the jury, the case that we have before you today is styled the state of Texas versus Rachel Marie Primo. The defendant and her counsel and the counsel for the state and all members of the jury, let the record reflect, are present. You have been summoned here in this court as prospective jurors on this criminal case. The defendant, Ms. Rachel Marie Primo, is represented by her attorney, Attorney Wright Kimler. The state is represented by Assistant District Attorney, Attorney Tommy Coleman. And sitting second chair is Assistant District Attorney Lamar Johnson. He's in the jury box. Our court reporter here today is Miss Ada Christie. She will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff is Mr. Charlie Porter. The defendant stands charged by information with the Class A misdemeanor offense of possession of a controlled substance. And the punishment range for a Class A misdemeanor is a fine from $0 to $4,000, confinement from 0 days to 365 days, or both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you will prefer not to answer certain questions in the presence of the panel, just say so. And I will ask you to come up to the bench so that we can discuss it more privately. And we have this device that will create sound so that no one will be able to hear what is being said. And just for the record as well, the state is also sitting, I guess, second or third chair, Mr. Ray Shearer. He's in the jury box as well. State, are you ready to proceed?
Yes, Your Honor. State ready to proceed.
Defense, are you ready to proceed? Mr. Coleman, the panel is yours, and please limit your examination to 30 minutes.
Thank you, Your Honor. Good afternoon, everyone. Again, my name is Tommy Coleman, one of the assistant district attorneys here in Jefferson County. I used to begin this examination by apologizing for the time and interference on your day-to-day life and activity that showing up for jury duty imposes upon you. But I don't do that anymore. I don't apologize for that because this is important. This is important to Rachel Primo. This is important to the Jefferson County District Attorney's Office. So I don't apologize for the inconvenience, but what I will do is I'll make you a deal if you give me your undivided attention, answer my questions truthfully and honestly, engage me in a back and forth discussion. I'll do my very best to limit my remarks to 20 minutes. While the judge is giving me 30, I'll do my best to give you back 10 minutes. Because again, this is important. This is important to me. It's important to defend it. I know from my perspective, if I were on trial, I want jurors, potential jurors to be here and give it their undivided attention to do it. I expect the same as people do. So while this has been a hassle, I have no doubt this is taking up a lot of time today, and it has been a arduous process. It's important, and I thank you on behalf of the Jefferson County District Attorney's Office for being here today. I've looked at your jury questionnaires, and if for any reason you guys have a problem hearing me, please just raise your hand. I feel like I'm yelling at the people in the front row, and I'm not speaking loud enough to the folks back there in the back. But I looked at your jury questionnaires. I know a little bit about each and every one of you. For instance, I know Mr. Tran, you're a machinist. Mr. Fogarty, I know you're a truck driver. Ms. Newhouse, you work at the food bank, right? Are you a volunteer or are you an employee?
At one point, I was an employee, but I just had to leave there.
So I think it's only fair, since I know a little bit about each and every one of you, that I tell you a little bit about myself. But for the time I've spent in the state of Texas, but for the time I've spent in the military, I've been a resident of the state of Texas my entire life. Undergrad in Fort Worth, Texas Wesleyan University, law school at South Texas College of Law in Houston. I've been a prosecutor for more than a decade, and I truly enjoy being a prosecutor. Contrary to what some people may believe, being a prosecutor is not about securing convictions and sending people to jail. It's about securing justice. By statute that are required is to seek and achieve justice, and that's what I want in this case for this defendant, is justice in this case. So how do we get there? Well, we get there by finding 6 of you who will hear, or determining or selecting 6 of you who will hear the evidence in this case, weigh that evidence and make a determination based on that evidence in this case. Okay? And we don't get there by you guys giving me the answers that you think I want to hear, or the answers that you think the defense counsel wants to hear, or even the answers that you think the judge wants to hear. We get there by you giving us your honest and truthful answers. You don't have to agree with me. You don't even have to agree with the law. In fact, in routine, this is not a marijuana case, so I feel comfortable in talking to you about this. Frequent in marijuana cases. Now, in this current climate of decriminalization and legalization of marijuana, we frequently get people in here, potential jurors, who say, I believe that marijuana should be legal. And that's fine. You know, if that's the way you believe. Now is the time to say it, because once you're sworn in as jurors and you take that oath as a juror or follow the law, you're sitting in that jury box. If you believe that I've proven my case beyond a reasonable doubt, whether or not you agree with the law or not, you're bound to follow that law. So now's the time to tell this court whether or not you have some issue with the law. For instance, Ms. Fisher, when I talk about giving me your honest opinions, I mean, if I tell you that this is my favorite tie, and when I put this tie on, it makes me feel like I'm a couple inches taller. If you don't like this tie, and your honest opinion is that it's the god awful of your tie, I expect you to say it. You know? Now, it's a silly example, but I'm trying to drive home a point. And the point is, this is the time for you to tell me how you really feel about the issue in this case. Does everybody understand where I'm coming from? And I'm not trying to minimize the seriousness of this, but from time to time during our discussion, I'm going to use some silly examples to try to drive home, or some comical examples, at least I think, to drive home a point, make a point. But again, I'm not minimizing how important this is to our office, to the district attorney's office, if it's defended. You don't need any special knowledge or skill to be a juror. You just need your common sense. I mean, I've got Mr. White, you're a truck driver, right? I mean, you don't have a legal background, I don't think, right? You need to get that in your question. But what you do have is your life experience. You have common sense, and I've seen it myself where jurors get on this jury and they want to, for whatever reason, dispense with or throw away their common sense when they're looking at the evidence or listening to the testimony. I mean, I'll give you one of my, what I call silly examples. If I were to tell you, Mr. White, that, you heard about my background, undergrad and law school. If I told you between undergrad and law school, I played a couple seasons in the NBA, what would your common sense tell you about that?
Could happen.
It could happen, but what would your common sense tell you about that? No. Exactly. And and why is that, Mr. White?
Probably because of the height.
Yeah, vertically challenged, But if I brought in evidence to you, maybe brought my old coach in from the NBA, that maybe brought in a video of me slammed up in the basketball, after you reviewed that evidence in light of your common sense, then you may tend to believe it, correct? But my point is, again, ladies and gentlemen, with these examples I'm trying to drive home, the point is, don't dispense with your common sense. You don't need to be a lawyer or someone who studies law to be an appropriate juror in this case. Now, we talk about appropriate jurors. I'll tell you an example of being an inappropriate juror. Let's see, whoever I'm not talking to. Let's see, Miss Shirley, you're a nurse, right? You're my only nurse on this jury panel. An example of being an inappropriate juror would be if last night, Miss Shirley, your home was broken into, some of your most valuable things, some of your most sentimental things were taken during that burglary, and you show up here today only to find out that this defendant is on trial for burglary. Even though you may think you're a fair and impartial person, could you see how maybe that could affect your ability to listen to the evidence in this case? The way the evidence is said. And very well, your experience being murderized the night before could very well be in back. So that's kind of what I'm getting is, while you all have your life experiences, your common sense, there may be certain things in your background that may predispose you to discount the evidence in one way or the other. And I want to make sure that we address that. Now, while I can't tell you or talk to you about the facts in this case, I can tell you that this defendant is charged with possession of a controlled substance. And in this case, it is a drug that's known as clonazepam. Maybe butchering their name, Miss Shirley. Are you familiar with the drug? Clonazepam? Clonazepam. Thank you. The Texas Controlled Substance Act says that it is illegal for someone to possess that drug without a prescription. Okay. In fact, the Controlled Substance Act lists many drugs that you cannot possess without a prescription. Going back to my marijuana example, where some people may think, well, marijuana, You know, is there anybody here who thinks, that it's a bad law on the books to say that certain drugs that are prescribed by, ordinarily prescribed by a pharmacist, should be legal? Mr. Rodriguez, what are your thoughts on that?
I don't know.
The question is, should all drugs be legal? Or what do you think about legalization of certain drugs that should be prescribed by a pharmacist?
Because some drugs are stronger than others. Others are much more.
Addicted perhaps?
Addictive than others and do more damage to if not prescribed properly.
Mr. Fogarty, what do people, or some people tend to do with these drugs that they come in, that they get a hold of? Do they always keep them for their personal use, or?
Oh, well, some of them sell it. Some people actually take, DV, various things can happen.
Sure.
Sure. Yeah, that's, probably a lot of them do sell, prescription drugs.
So
Like
back
if
to
they're
my,
short on cash, they'll sell the drugs for money. So they can get, like household essentials or whatever,
back to my, thank you, Mr. Fogarty. So back to my original question, is there anybody, this is a really important question, so I'm gonna go row by row here. Is there anybody on this first row who believes that all drugs should be legal? Raise your hand. No? No? Anybody disagree with the legislature classifying certain drugs, that are prescription only? If you have it and you don't have a prescription, it's illegal. Anybody have a problem with that legislative approach? So me and the first. That's, for the record, there are no hands being raised in this. Now, I'm not talking to myself. From time to time, I want to make sure the record is clear. That there, since she's taking everything down, I want to make sure the record is clear. When someone raises their hand, I don't identify my computer on your name. And if nobody raises their hand, nobody in the first row raise their hand. Second question for you guys on the second row, Ms. Wise, working for your row there. I just made that row. Anybody on Mrs. Wise, row, same question. Think that all drugs, particularly those drugs that require prescription, should be legal? No? All right, for purposes of the record, nobody has raised their hands. Thank you. The next row there is Mr. Norrisworthy, lab tech, all right? Do you analyze drugs in your position as capacity lab tech? Refinery. Oh, it's a refinery. Oh, totally different. Anybody on that row who believes that all drugs are legal, or the drugs that require prescription? I mean, if you think about it, nobody's right there. If you think about help me with your name, Mr. Holmes. If you think about it, I mean, what's the whole point of it requiring a prescription in the first place?
One piece of somebody that medically needs that prescribed versus somebody that may not need it.
Sure. And those drugs that are typically prescribed, I mean, we're not talking about something, what's been your life experience with drugs that require prescription? Are they stronger or weaker than the over-the-counter stuff?
Why can't it be stronger?
Mr. Woods, you're number 12, what do you think?
I'm a disabled vet, so I'll take a whole bunch of them. I think that is good and regulated, because if you're a vet, you get a whole bunch of drugs. You just can give about a bag full of meat.
Sure.
It shouldn't be given to people that are not prescribed to them.
Appreciate that, Mr. Woods. Anybody on the last row back there? Ms. Hughes, I haven't talked to you. What are your thoughts on this?
I definitely think they need to be regulated.
Anybody else, Mr. Burke? So no one on the back row back there, Ms. Thomas? Ma'am? Thompson. Yeah, anything on that, Ms. Thompson?
No, I was a CNA I worked in long-term care for 10 years, so I understand exactly why.
All right, I think I'll move on. I think I've made my point with that. Now, the judge alluded to this, and I will just reiterate this really briefly. The fact that this particular offense is a misdemeanor offense. Nobody going to prison if they're found guilty of this offense. They do face, some jail time in county jail, up to a year in county jail, anywhere from 1 day, or actually from no day, up to a year in jail, depending on, what the jury determines. Or they can face a fine of up to, $2,000, no, $4,000. Yeah, a fine of either $0 or up to $4,000. Again, determining based on what the jury determined. One thing that the judge didn't mention is probation is an option in appropriate cases. So we've got fine, we've got probation in certain circumstances, and then we've got a jail option as well. Ms. Love, what do you think about those options? Can you envision situations where just the fine only is appropriate? No?
No. I think, when drugs are involved, depending on the situation, treatment should also be an option,
Sure.
not just,
And thanks for your honesty. I appreciate that. I will say this, and Mr. Kimler, when he has his opportunity to address you, he has a different take on it, certainly can let you know, but that probation option also encompassed with the probation, there's an opportunity to grow. So could you consider probation? It sounds like we with drug use. What about in the appropriate circumstances where you feel jail time is appropriate? Could you consider jail time as well?
I don't know, to be honest, because I'm more focused on the reason why the person has a controlled substance. And if there is any misuse there for that person.
And let me, I'm gonna have to kind of pin you down a little bit on this, because it's really important. I'm sure Mr. Kim is gonna follow up on this, but let me ask you this. Could you at least consider the full range of punishment? In other words,
We're on to the court.
I didn't know, it's news to me, Judge. Thanks for letting me know, Mr. Kim.
I didn't follow the punishment. So it's on.
All right, thank you. Here's how it works in Texas. Texas, the defendant can elect, if they're found guilty, can elect for either the jury to set punishment, or they can elect for the judge or the court to set punishment. So I just found out that this defendant has elected, if in the event she's found guilty, that she wants the court and judge to set punishment. So now that changes my whole question, my line of questioning. Now my questioning is there anyone here who could not simply determine that somebody is guilty or not guilty and not have a hand in the punishment? Sometimes we get jurors, Mr. Tran, who say, if I'm going to make a determination if somebody's guilty, I want to assess punishment. So is there anybody here who feels that way? Is there anybody here who could not consider guilt or innocence and then determine that the judge or that the court determine the appropriate punishment? Either that fine we talked about on probation or jail time. Is there anybody here? Raise your hand if there's anybody here who feels that way. For purposes of the record, no hands have been raised. Thank you, Mr. Gilmer. I think this takes about 5 minutes. I want to talk about beyond the reasonable doubt. Texas, that's the standard by which the state would prove its case is beyond the reasonable doubt. Not like on TV and where they talk about beyond a shadow of doubt, whatever that means. Beyond the reasonable doubt is the standard here in Texas that we must prove our case. In other words, that we must convince you that the crime occurred. And, there is no definition in Texas of beyond the reasonable doubt. Okay, it's what you feel. It's what you believe, Mr. White, in your gut. You know, again, using that common sense, using your life experience, what you believe rises to the level of being beyond a reasonable doubt. I mean, I guess in certain circumstances, Mr. Northworthy, someone could say aliens came down and they inhabited someone's body and took over and made them do what they did, and that's the reason why they're not guilty. But what does your common sense say about it? Okay. Again, no silly example, but kind of the point, and hopefully, the point is being made is that If there's a doubt, you ask yourself, do you feel that this doubt, is beyond a reasonable doubt? I mean, I suppose anything's possible, right, Mr. Noseworthy? Am I pronouncing that correctly?
Yes.
Let me put it this way. While there is no definition of beyond a reasonable doubt, I can tell you what beyond a reasonable doubt is not misused. It is not doubt beyond to 100% certainty. In other words, the law doesn't require me to prove my case to 100% certainty, okay? I mean, because if you think about it, Ms. Newhouse, what's the only way for you to know something happened with 100% certainty?
If I saw it, I was there myself.
That's exactly right. If you saw it and you were there yourself, and that would make you a witness, and you wouldn't be here as a potential juror, you'd be on my witness list, and I'd be calling you as a witness instead. So the law recognizes that that's the only way for you to know something with 100% certainty. So it doesn't require me to prove it to you by 100% certainty. In other words, Ms. Wise, I don't have to bring you like they do on the TV show, you know, satellite photos, DNA. I don't have to have 6 months to say that they saw this thing happen. All I need to do is convince you, to whatever degree you believe is beyond a reason, that this offense occurred. Okay? Is there anybody here? This is an important question, so please, row by row again. Anybody on the first row would require me to prove my case to 100% certainty. Beyond all doubt, because that's not what the definition is. Just beyond a doubt that's reasonable. Anybody, no hands have been raised. On the second row, anybody who would require me to prove my case with 100% certainty, please raise your hand. No hands have been raised. And on the third row there, Mr. Sulo girl here, anybody would require me to prove it with 100% certainty. No hands have been raised. On the last row, anybody who's trying, Mr. Burns, I have to talk to you. You're welder, right?
That's what I did on now, quality control.
Okay. Very good. I think I watched the MIG welding, TIG welding. I love that stuff. I mean, that's the whole conference for another day. I'm gonna keep moving. So nobody is gonna require me to prove my case beyond all doubt or with 100% certainty, because that's not the standard. But make no mistake, there will be evidence, and you will hear from at least a witness or two as it relates to this case. And it may be a law enforcement witness. And I will ask you this, please do not give that law enforcement witness any more credibility than you would any other witness, at least starting out. Because this defendant has certain rights. She has the right not to testify. She has the right to be presumed innocent. And she has the right for the witnesses to start off at the same level as any other witness. Now, once you've heard about that officer's training and background and their experience, then you can give them all the credibility that you want. But what I would ask you to do, in fairness to this defendant, is to wait until you hear the testimony from the officer. It's because they come in here with a shiny uniform and a shiny badge and a fresh uniform. Do not, I ask, give the officer more credibility than you would any other witness, at least to start with. Can I get you to promise it? All right. And we talked about this briefly. She has a right not to testify against herself. Is there anybody here who, at the end of this case, if she doesn't take the stand, would use that as evidence of guilt? I mean, we're only human. We would want to hear from them. And if it were you, you'd probably say, you know what, Ms. Fisher, you'd probably say, if it were me, I would get on that stand and scream from the top of my lungs that I didn't do it. But she doesn't have to do that. I am required to prove that. So with that being said, is there anybody here who, while you may want to know, you may like to hear from her, but if I tell you the law says you can't hold that against her or use that as proof of her guilt, could you follow it? Is there anybody here who couldn't do it? For the record, no one's raising their hand. So right now, all the witnesses start off at the same level, right not to testify, and she is presumed innocent. In fact, if I ask you right now, as she sits here, to vote on whether or not she's innocent or whether or not she's guilty, what must your verdict be, Miss Shirley? What must your verdict be? She's not guilty. You haven't heard a word testimony. You haven't seen one exhibit. So if she sits here, she is presumed innocent. So, with that being said, I'm nearing the end of my outline here. Is there anybody here, and this is probably one of the instances where, like I just talked about, if it's too personal, we can approach talk to the judge. Is there anybody here whose life has been touched by drugs? To a degree, like we talked about with the burglary example, where you think you might not be a fair juror in the case. Mr. Burke, I got your hand. Let me work my way row by row when I get to you, Mr. Burke. And what I'm talking about on this first row, guys, is either you or family member or close friend has either been maybe drug addicted, maybe arrested for drug offense, or a victim of some offense that involves drugs. So anybody here in the first row who has had that experience, please raise your hand. Or you can raise your hand and say, hey, look, I want to talk to you about that with the judge outside of the hearing. Everybody else. Raise your hand if you had that kind of experience. For purposes of the record, no one is raising their hand. I'm going to get back there to you, Ms. Thompson. Give me a second. Second row, Ms. Wise's row there, again, the authority, anybody on that row who has been affected some way, somehow, significant degree by either drug use or abuse. Feel like that experience will keep you from being very good. So, for the purposes of the record, no hands will be raised. Judge, how are we doing on time?
You have 5.5 minutes.
All right, I'm gonna wrap it up. Mr. Northworthy, that row there, third row, anybody been affected by drugs, to a significant degree, can be affected? No hands are getting raised in that last row. Ms. Thompson, is that something we need to go talk about from the judge?
Yeah.
Okay, we're happy to do that. Anybody else in that row? Mr. Birch, we got you, we'll call him. Anybody else? Other than you're number 13, number 16. Guys, I appreciate your time. You give me your undivided attention and you've answered our questions. When I asked, is there anybody here who knows Miss Primo, Rachel Primo? Anybody here who knows her defense counsel, Mr. Wright Kinlan? No hands have been raised. Is there one last question I'd like to ask? Is there anything that I didn't touch upon that I didn't ask? You're sitting there thinking, my God, if he would have just asked me this question, one question, I would have given him an earful. Anything like that? All right. All right.
I do know the judge. I mean, I've met the judge before.
Oh, the judge knows a lot of people.
Okay.
Let me ask you this. Is the fact that you know or have met the judge, would that prevent you from being a fair juror?
No.
From listening to the evidence and weighing that evidence and making decisions just based on the evidence, not because you know the judge.
Exactly.
So anything that you guys want to bring up at this point about the issues that you think surrounding it? All right, I look forward to presenting my case to the city who are chosen to sit in the spirit. Thanks.
Mr. Kimler?
Absolutely.
Yes, you may proceed.
Afternoon, ladies and
Oh,
gentlemen.
Mr. Kimler, before you proceed, is that somebody's phone going off? If you make sure that your phone's up on mute. Okay, you may proceed.
I like to move a little closer to the business side of the Houston. Just to clear something up, Texas is one of the few jurisdictions in the country that allows a jury to set the punishment in a case in the event of a conviction. Most states, I think Texas and Arizona are the only states. But what it requires is that the defense file a motion before we commence the jury examination questioning prior to that commencing, telling the court that we've elected to have the jury set punishment. And if you're seeking probation from a jury, it requires a sworn motion or application for probation stating that you've never been convicted of a felony in this or any other jurisdiction to qualify for the jury to probation. And that's because I said required to be filed prior to the commencement of the board examination. If that's not filed, if that punishment is filed, then by default you're going to the court. So I assume by not filing that in this case, that the state will be on notice that we're warning the court for punishment. So I apologize, Mr. Holmes, for that. But you have to file that before that election, that punishment election, before this process commences in order for the jury to set.
And this misdemeanor case, both misdemeanor cases, is knowledge, I go to the courts for punishment, whether it's Judge Holmes or Judge Wood, because they're predictable, you know, kind of what they're gonna do on punishment. It's not like felony cases where many times with the district court judges that we have, their juries may be more lenient than what a district court judge might be in a case, and it's better off trying to look with the jury on sentencing than any of the district court judges. But generally speaking, on misdemeanors, yeah, there's that predictability that, you know, what Judge Woods and Judge Holmes will do in these misdemeanor cases. And just because this is a misdemeanor case, it doesn't mean it's not important. You heard, Judge Holmes say that somebody could be sentenced to a year in jail for this offense. That's gonna be the product of the court in the event Mr. Coleman is able to convince those that are chosen beyond a reasonable doubt that he's proven everything he needs to prove, and he's excluded every reasonable doubt you might have about his proof. This case is, I think, 3 years old. It's kind of an old case. Unfortunately, that's a situation that we're faced here in this county with a lot of cases. We're kind of getting old because of the COVID situation and other things. And so we'll just see, we'll see what the recollection is of the witnesses and things like that, and how much time has affected those types of things. Now, when you walked in, and you saw this pretty much sitting at the table here, did you ask yourself, well, gee, I wonder what this individual did to be in court today? What did she do wrong to be here? Mr. Let's see, Ms. Fisher, what did you do? Ask yourself that question?
No,
Why not?
I have a lot of experience with, law, I'm paralegal. So-
Okay, with criminal law,
Well, I don't do it.
but I guess maybe as part of your training, you have some. Why didn't you ask yourself that? I mean, she's sitting here, we've got a jury coming in, you got, bailiffs and everything else. Why don't you think that she's done something wrong with you?
The main thing that I would think is I'm going to let the evidence speak for itself. I put myself in her shoes. If I was up there, I wouldn't want people to walk in and immediately be like,
What did you do wrong?
and so I'm kind of putting it as I want to see more. I'm not gonna, automatically decide.
Even if she's done something wrong,
Right.
anything. Ms. Fogler, what do you think? Did you ask yourself that question? What did you?
No, actually, I'd like to read your assistant.
Oh, okay. I asked that question many years back to the jury panel. Down and raised his hand. I thought you would. So, but knowing that she is charged with this, does that affect you on whether or not you think she's done anything wrong at this point in the proceedings?
No.
Why not?
Well, I mean, first of all, there's no evidence been brought forward to
Right.
even, she's been accused and that's it.
Well, she's been charged, right? I mean, the state of Texas, Mr. Coleman, and the gentleman from the district attorney's office, I assume whatever law enforcement agency has brought charges, so they must be.
And like you said, it's been 3 years ago.
Right. But they're all saying she's done something wrong. Does that affect you? You think that she's done something wrong?
No, not at all. Like Mr. Coleman said, they have to prove it.
Okay. And the fact that she's been charged means what?
I mean, that's.
But anything. I guess what it means is that it gives Judge Holmes the obligation to bring people in and form a jury to hear evidence, right? That gives him the authority or jurisdiction to do that. And that's what the charge is. It's jurisdiction. It's not evidentiary. It's not evidence of guilt.
Right.
Does anybody here think at this point that she's done anything wrong? Right? Just, Thompson, is that right? Or Hughes, right? Presumed to be innocent, right? Everybody's right, presumed to be innocent. What does that mean, Mr. Tran, presumed to be innocent? Right there?
Not guilty at this point.
Well, it's more than that, she's presumed innocent, right? She's presumed to be, there's nothing wrong, yes, right? The juries find people innocent. How many people are not this, you nod your head or agree with it? Juries find people innocent. Now, who all agrees with it? Show my hand. Mr. Write these down, Mr. What's your name? Norwood. Why do you say that? Juries find people innocent.
They didn't prove they were not. I mean, they were innocent.
What is, you heard Mr. Coleman going, Mr. Coleman say, I don't have to prove it 100%, not proof beyond all possible doubt, it's not 100% certainty for it to be guilty, right? Yes, ma'am.
I guess I need to clarify.
All right.
Juries return verdicts of innocence. There's no, and I didn't catch it when you first said it, there's no, innocence does not have to be proven
Mhm.
because it is presumed
Okay, so how do you overcome the presumption of innocence?
with the burden of proof.
How does the state overcome the presumption of innocence?
They've got to basically layer the proof. And it goes back to that reasonable, you know, when you're looking at everything, the evidence has to, the story the state is telling has to make logical, reasonable sense and be over, you know, with, beyond that
Beyond what?
reasonable doubt.
The
Right?
state has to prove beyond a reasonable doubt. And if they do that, what's the verdict?
Then the verdict is guilty.
And we know that guilty doesn't mean 100%, right? Not certain. How do we know that? How do you have guilty is not 100% certain?
Because like they said.
How do we know that? How do we know that guilty is not 100% certain? Anyway.
Unless you were there.
Unless you, yeah.
Well, we know because people have been convicted beyond a reasonable doubt, right, and later proved to be innocent.
Yeah.
Right, and that's what you know, it's not beyond all possible doubt, because innocent people get convicted. And how do you know innocent people get convicted? Later on, anybody heard you take DNA, right? You're at the DNA, how many people are exonerated? There's a guy was watching stuff on YouTube the other day, 37 years this guy's been on death row in Florida for a murder. DNA comes along, they run the cold case, they run it through the database, they just, turns out he didn't do it. We got the match of the guy that did it. 37 years, this guy's waiting to be executed. And he's innocent, and convicted beyond a reasonable doubt. So it's not absolute certainty, he's absolutely right. But what do you think? Is it something close to that? I mean, how close does it have to be to certainty before you're willing to say we're gonna subject somebody? Of course, she's not facing the death. But how high of a standard does that have to be? And Judge Holmes isn't gonna help you. He's not gonna give you a definition. He's gonna tell you it's not proof beyond all possible doubt. State's not required to prove that. But the state must exclude every reasonable doubt that you have before you can convict. Now, getting back to what I was asking you before, the juries find people innocent on the other end of the spectrum. Mr. Fasula, what do you think?
Yes, they do.
Okay, so 100%, your verdict is you got 100% innocent. Didn't do it, the same end as 100% of the other end guilty. Well, I'll make it easy. Juries find people not guilty, right? Okay, not guilty. Is not guilty innocent? No, not guilty is not guilty. Not guilty is fancy benefit, right? Juries don't find people innocent. Okay? There's not a jury in this country that finds people. They're not required, just like it's not 100% on guilty. It's not 100% on the other, it's just not guilty. There's been some failure in the state's proof where they haven't excluded every reasonable doubt that you have when you say not guilty. Like, we don't, it's not guilty. I'm not saying she's innocent. We're just saying she's not guilty. And the result of that is people aren't convicted and they're not subjected to punishment. That's for the real gist of a guilty verdict. Is it empowers the state government to punish somebody. And where does that power rest in our system for the states alone? Rest with the people, with the jury. Then the government doesn't get to make that decision on their own. As trustworthy as Mr. Coleman and the district attorney's office is, I believe, as trustworthy as they may be, they don't have that power. The system doesn't give them that power to make a decision on their own punishment. They have to convince people from the community beyond a reasonable doubt to convict somebody before the person can be subjected to punishment. So that's what that's the role of jury, or fact finder, or arbiters of the proof of whether the state's done it or not. I hesitate to say a fact finder, because you really don't find that. You just evaluate the evidence and ask yourselves, are you satisfied beyond a reasonable doubt the person should be convicted of that? All right, everybody can do that. Anybody have any problems with that? I always kind of smile when, I hear Judge Holmes, he's instructing on, he's saying that, I want fair and impartial jurors. I think people think I want fair and impartial. If I were selecting people, picking people, that I would select fair and impartial people.
Sure you would.
Why? Why would I select fair and impartial? Who would I select? Who would you select? If you were trying to win, right? Would you select people that are,
Well,
you select,
it depended on what kind of information I had about each individual, as to how everything went, like Mr. Coleman said, he's got our questionnaires. He knows quite a bit about us, which we know absolutely about nobody in this room.
right?
So I mean, that's like you probably had a chance to see all of our questionnaires, right?
Mhm.
So pretty much.
But see, the system is, I don't select people. We deselect, we strike them.
Right.
So I'm not looking, I don't get to pick people I like.
Right.
I have to get rid of people that I think aren't favorable to my side.
Exactly.
Now, if it was the other way around, if I got to pick people that I like, Mr. Coleman got to pick people he liked, what do you think what would we end up in?
Right. Yeah.
100.
Yeah.
If I got to pick who I wanted to serve, I'd be looking for people that are biased in my favor.
Yeah.
They're fair and impartial. I want people that are biased in my, right? I mean, that makes sense. I don't know, maybe there will be some lawyers that would, but I would be looking for people that are on my side. That don't trust the state, don't like the state, whatever. But that's not, it's not the system. We have to identify people that we think for whatever reason aren't fair and impartial.
Right.
They're going to be biased in favor of the other side, and those are the ones we strike. And so the theory is the first, in this case, it's a misdemeanor, we each have 3 strikes. But the first 6 people who aren't struck by either side, well, that's the jury. Does that make sense? Right?
Right.
It's just like Mr. Cole was asking all about, experience with drugs or people that have had issues, I suppose, with family members or loved ones that have drug abuse problems, things like that. But that might call in your own, or question your ability to be fair and impartial. Is there anyone here that thinks for some reason that this case involves a class of controlled substance, a misdemeanor prescription drug, that they can't be fair and impartial? Or they were biased against the defendant? No? Okay. What about, this is the last thing I want to cover with y'all. As far as evaluating, well, let me ask you this way. Everybody understands we have a right as citizens in this country to be free from unreasonable searches and seizures from the police, right?
Could you say that again? 'Cause
I'm sorry. That as citizens, actually non-citizens too, we have the right to be free from unreasonable searches and seizures by law enforcement, by the police. Thank you. Agree with that, Ms.
Ms. Newhouse, and
Yeah.
yes, I do agree with that. It's just that you dropped an octave.
I'm sorry. Why do you agree with that? Why is that important? That people are free that we're free from what are called unreasonable searches and seizures?
Because I don't think anybody has a right to touch me and search me and just because they want to.
Right.
There needs to be a reason, a good solid reason for them to.
Or to be in a living in a free society, right? We should be generally left alone unless there's some good reason for us to be searched or a house to be searched. Do anybody disagree with that there should be limitations on the scope of police powers when they're conducting searches and seizures? Mr. Burks, do you agree with that? I'm sorry.
I'm with her on, your question kind of confused me, but I'm agreeing with what she is. I mean, I would feel the same way. I would, because I feel like that'd be an invasion of privacy.
Right. You don't have a problem limiting the power of police to conduct searches.
Yes, not.
Right. Shouldn't they just, whenever they want to, they can stop you and frisk you, or kick your door, or open your door and search your house, all right? Why do you think that's important, to limit the power?
I mean, go back to me being guilty until proven innocent. on whatever the case may be.
Well, anybody else have any thoughts? Mr. Northwood, what do you think? Why do you agree that police powers should be limited when it comes to searches and seizures?
And I do agree. My son is a police officer and he'll agree.
Where is he a police officer?
He is a detective with Beaumont.
Okay, I think I read that. And he agreed with that, right? Ms. Nina, Ms. Hughes, here, Lamar, here,
Common sense.
Thompson. You agree with that, Ms. Thompson?
Absolutely agree with that.
Huh?
I absolutely agree that
Why?
there needs to be limits.
Why is it even?
Because because it's just not like, if you decide on a whim, you know, you wanted to stop and, you know, tell me you're going home with me to search my entire house without reason, that's more than invasion of privacy. There's so many things wrong with that. You have to know what and why and what you're looking for and things of that nature.
Part of being, part of freedom, right?
Part of freedom, absolutely.
This, Love, what do you think?
Ms. Shirley?
Shirley, I'm sorry, I'm not sure. Ms. Shirley, what do you?
Oh, there definitely should be limitations on search and seizure.
Why it'd be a lot easier, wouldn't it, if we didn't do it? Just let them do it if they want to, we got so much crime, just.
Well, that's what was done, you know, years ago, and that's part of why that became part of the law, is because it was abused. Power is easily abused when it's not regulated. So there was no justice system.
Well, let me ask you this, and sometimes, in some circumstances, Judge Holmes will give you an instruction as jurors that when there's a question of fact, there's a disputed issue of fact that relates to the legality of the search. In other words, there's a disagreement in the proof as far as a necessary fact to make the search legal. That a jury gets to pass on that fact, not the innocence or not the guilt of the defendant, but on that fact that the state has to establish in order for the search to be legal. All right, does that make sense to everybody? I'll give you an example. Let's say that the reason for the traffic stop was somebody ran a stop sign. Right? And there's a question when the person testifies, I didn't run the stop sign, and the officer says they did run the stop sign. And so for order for you to consider what was found in the search as a result of the traffic stop, you got to believe beyond a reasonable doubt that the defendant ran the stop sign. Okay, and the judge will give you that instruction. Do you think that you could fairly evaluate that and just not go with the police and their burden, like Mr. Coleman was telling you? Right? And hold the state to that burden. Do you think that that's fair? Right? Does anybody disagree with that? Would you have a problem telling the police, no, you're wrong? We don't agree with your burden. We're not going to consider the evidence. We don't believe it beyond a reasonable doubt. Does anybody have a problem telling the police they're wrong? Anybody? No? No? Miss Fisher?
Yes,
You wouldn't?
no,
Ms. Wise?
Right here.
Wise?
I was in a car, I was hit by a driver right here on Liberty,
Mhm.
and, the police wanted to give me a ticket and said that it was my fault.
Okay.
And of course, I said it was, and we had a very long discussion. And I said, I wasn't, you know, I'm not wrong.
And you disagree?
I disagree.
All right. Okay, I believe that's all I have. Anybody have any questions of me? I'll try to give you some time with it. No? Okay, thank you.
Okay, ladies and gentlemen of the jury, we're gonna ask that you follow the bailiff out into the hallway. And we're gonna call some of you back in so that the lawyers could have some follow-up questions with some of you. Okay, just follow the bailiff.
We need, right?